Counsel, can I ask you a question about the conscience injury? So that's one of the roadblocks you identify in the speculative chain, because you say a doctor could invoke federal conscience protections to refuse to complete an abortion that was when the embryo or fetus was still alive. So I just want to be clear, the federal government's position is that their doctor would have conscience objections. I'm thinking about the EMTALA litigation, and the Fifth Circuit criticized the government's inconsistent positions. But it is your position that such doctors would have recourse to the conscience protections of federal law?
Yes, absolutely. And let me be clear about this, because I think the Fifth Circuit did fundamentally misunderstand our arguments, and respondents have repeated that misunderstanding here. The federal government has never taken the position that EMTALA would override an individual doctor's conscience objections. We said exactly the opposite. If you go and look at our Fifth Circuit reply brief in the Texas litigation, we disclaimed that understanding of EMTALA and made clear that we understand the conscience protections to continue to apply and shield the doctor who doesn't want to provide care in violation of those protections.
Would that be true in a healthcare desert as well?
Yes. So we don't think that EMTALA would override conscience protections for the individual doctor. It, of course, imposes obligations on hospitals, and hospitals have all kinds of plans in place to address these types of contingencies. You know, they have staffing plans. I understand as a matter of best practices, they often ask for doctors to articulate their conscience objections in advance so they can take account of that in staffing. They have cross-staffing agreements with other hospitals. And in the government's experience enforcing EMTALA, this is almost 4 decades of experience, we are not aware of any situation where there has been that kind of direct conflict between EMTALA and conscience protection.
Okay, and just one last question. This is about the association standing. So its own standing in its own right. I'm talking about not its standing that is based on an injury to one of its members. So the injuries that the association is arguing sound in the Havens Realty associational standing, and they're the kinds of allegations we see by immigration advocacy groups. Diversion of resources, increased expenses that result from the complications of having to address and explain the new changes. And I'm not talking about the expenses of filing the petition. That's not what I'm talking about. Let's just talk about the diversion of resources. Can you distinguish that from Havens Realty?
Yes. So I think Havens itself was trying to distinguish between 2 types of potential organizational injuries. And what Havens said is that in that case, the organization had come forward with direct and concrete demonstrable injury to itself. And there, the organization had a contract to provide low-income housing or a search to secure it for clients, and the racial steering practices directly interfered with that, made it more difficult for the organization to carry out its contractual obligations. But Havens itself said that it was not blessing a theory of standing that would allow an organization to assert a setback to its abstract social interests. So I think that reflects the court trying to distinguish between more concrete, direct, demonstrable harms on the one hand, and that kind of abstract setback on the other hand. And I recognize, and your question touches on it, Justice Barrett, that some lower courts in particular have seemed to read Havens to endorse far broader theories of standing, including in the immigration context. The government has been routinely resisting standing because we think that that would essentially mean that any advocacy organization could say it opposes what the federal government is doing, and so therefore has to devote resources to that opposition. If that were enough, then every organization would have standing, and it would be a vast expansion of ordinary Article 3 principles. So we would welcome an eventual clarification from this court on organizational standing, but here I think that the organization's assertion of injury falls in the bucket of the abstract setback and doesn't come close to the kind of demonstrable harm that was at issue in Havens.
General, I'm sorry.